doctrine of breach of confidence is a legal action available under the common law that protects private, confidential information from unauthorized use or disclosure. When a breach of confidence claim is presented before trial in a court, the court, in order to determine whether or not a breach of confidence claim will be granted, must establish three matters, known as the three-question test. My presentation today will explore how I adopted a court's approach to a breach of confidence claim in order to determine whether or not a client company would have a legal right of action in breach of confidence against either a PR agency or unit coordinator for the unauthorized disclosure of confidential information. Confidential information is defined as any type of information that is described as being of private, confidential nature, that is known for its quality of confidence and existence outside the public domain. The law recognizes four general categories of confidential information. These four categories are commercial secrets, government information, private secrets, and professional information. Commercial secrets. Commercial secrets are commonly referred to as trade secrets. This category includes information such as processes, formula and designs, customer lists, and business secrets. Government information. Government information refers to information established as being confidential by the government. Examples include cabinet decisions and information concerning national security. Professional information. Professional information refers to information disclosed under specific professional relationships. Information under this category includes doctor records, lawyer instructions, and client information held by banking firms. Private secrets. Private secrets refer to information of private nature. Examples include personal information, artistic works, individual identity, reputation, and cultural information. Under the circumstances where the unauthorized use or disclosure of confidential information occurs, there is a legal action available under the common law known as the tort of breach of confidence. The equitable doctrine of breach of confidence is defined as an action that protects private information that is conveyed in confidence by providing an effective remedy to owners where no contractual protection exists. Where a breach of confidence claim is presented before a court, the court must establish three matters in order to determine whether or not a breach of confidence claim will be granted to the respective plaintiff. It is important for all three elements of this test to be satisfied before a breach of confidence claim can be granted. The three questions the court has to establish are as follows. Firstly, the court must assess whether or not the plaintiff's information have the necessary quality of confidence. Secondly, the court must establish whether or not the information was imparted to the defendant in circumstances importing an obligation to confidence. And thirdly, the court must determine whether or not the information was used without the authorization or consent of the plaintiff. So, in each of these steps, what does the court need to look at? Element 1. For Element 1, the court must determine whether or not the plaintiff's information has the necessary quality of confidence to qualify for protection under a breach of confidence claim. The court will look at the factors that affect the information's quality of confidence, such as the public domain. For information to have a quality of confidence, it must exist outside the public domain, because information within the public domain is not protected by a breach of confidence claim, as the information is too widely known. Information that is public knowledge does not qualify as confidential, and thus is not protected from unauthorized use by a breach of confidence claim. The court following this will apply the reasonable person test to the facts of the case in order to determine whether a duty of confidence exists. The test, however, also acts to determine whether the information is sufficiently secret to be capable of having the necessary quality of confidence for the duty to exist in the first place. The reasonable person will assume that no duty or obligation of confidence exists if the information in question doesn't have the necessary quality of confidence. Element 2. For Element 2, the court will determine whether or not the defendant had an obligation to confidence. An obligation to confidence arises where information with the necessary quality of confidence is imparted in circumstances importing an obligation of confidence. An obligation of confidence is imparted on the understanding that the information is to be treated by the confidant on a basis of confidentiality. The nature of the information, the purpose of the confidant communicating the information, and the form of communications by which the confidant states the restrictions upon the use of that information are all factors that are taken into consideration by the court when judging this element. Element 3. In this element, the court must consider whether or not the defendant used the confidential information without authorization or consent of the owner. So, applying the three-matter process to the case itself. So, question 1, does the information have the necessary quality of confidence? In this case, I determined that the client's confidential information had a quality of confidence because it existed outside the public domain, thus qualifying it for protection under the common law tort of breach of confidence. The plaintiff's information also had the necessary quality of confidence because the protection of reputation falls under the category of confidential information that is recognized by the law. If the court applied the reasonable person test to the facts of this case, a reasonable person would assume that because the information in this question has a necessary quality of confidence, then an obligation or duty of confidence is likely to exist. Question 2. Did the client impart the confidential information to the public relations agency or the unit coordinator in circumstances importing an obligation of confidence? In order for there to have been a valid duty of confidence, the client must have conveyed the confidential information to the PR agency or unit coordinator in circumstances that made it obvious that the information was of private, confidential nature that was not to be used without authorization. The PR agency had a duty of confidence to safeguard the client's confidential information because of the circumstances that imported the obligation. An obligation to a duty of confidence will exist where the parties are in a confidential relationship or where in contractual relations with confidentiality undertakings. The PR agency was engaged by the client company to prepare some internal communications to staff. In essence, it can be assumed that the client company effectively employed the PR agency. If the PR agency was engaged in employment with the client company, the parties in this case were involved in a confidential relationship as employer and employee. This means that the PR agency had a duty of confidence in safeguarding the confidential information because an obligation of confidence exists where information is imparted in the circumstances where parties are in a confidential relationship. As the parties in this case were engaged in confidential relations, it is likely that the PR agency would have needed to sign a contract of confidential undertakings and employment before commencing work. As the client was anxious to preserve its reputation and not panic staff, it is highly likely that the client would have included a term or clause of confidentiality in the contract. Contracts of confidential undertakings are legally enforceable obligations to maintain confidence in a contract. Under the circumstances where the parties are engaged in contractual relations with confidentiality undertakings, an obligation to a duty of confidence will exist. Therefore, the PR agency was bound by a duty of confidence to safeguard the client's confidential information and not disclose or use that information without authorization or consent. The unit coordinator, on the other hand, did not have a duty of confidence to the client because the client did not impart the confidential information to her in circumstances imparting an obligation of confidence. By the time the unit coordinator received the client's information through her work placement student's blog assignment, the information was effectively within the public domain. The client cannot take action against the unit coordinator because the unit coordinator had no duty of confidence against the client's information. In this case, she would be considered to be part of the public domain. Question 3. Did the PR agency disclose or use the client's information without authorization? The work placement student Eric disclosed the client's confidential information to his unit coordinator through a blog without authorization from the client. The very moment that Eric published the confidential information along with the client's name on the blog post, the information was effectively in the public domain. In doing this, Eric not only breached the duty of confidence to his client, but his duty of confidentiality to the Public Relations Institute of Australia, whose code of ethics requires all public relationists and consultancies to safeguard the past, present, and future confidences of all clients. Because the PR student agency was responsible for making sure that the work placement student didn't breach the consultancy's duty of confidence, the PR agency was effectively at fault for the disclosure of the client's information. While it can be argued that the PR agency likely would have expected the work placement student to know better than to disclose the client's confidential information to a third party, it can be said in defense that the Public Relations Agency also had a duty to make sure that the student didn't compromise their work or reputation by releasing the client's confidential information in the first place. Therefore, I determined through the use of the court's approach that if the facts of this case were presented before a court, that the client company would have a legal right of action in breach of confidence against the PR agency, but not against the unit coordinator, because she had no duty of confidence. The client would have had a legal right of action against the PR company for disclosing confidential information without authorization or consent on the grounds that they had breached their duty of confidence. The client's information had a necessary quality of confidence, plus the clients imparted the information to the PR agency in circumstances imparting an obligation of confidence. However, because the PR agency's work placement student disclosed the client's information without authorization, the consultancy was not only in breach of their duty of confidence to the client, but their duty to the PR Code of Ethics. The Public Relations Agency's failure to make sure its work placement student did not breach its duty of confidence led to the PR agency's demise. The client company will have a right of legal action in breach of confidence against the PR company, under which they can claim a remedy in the form of damages or an injunction. Thank you for listening to my presentation.